So, my lady, access was provided to the server. And indulge me, I read something that was noted by the registrar on page 17, supervised access. Agents were granted supervised access to the live server through an interactive session. All their concerns and questions were exhaustively answered through querying of server for logs, not by mouth, not by explanation, by their own queries to the server. My lords, my ladies, I was there. Mr. George, for the petitioners, dictated specific queries. They were run in the system, and he was completely satisfied. That is the registrar's comment, not the IEBC's comment. As such, the statement that they were denied access is factually inconsistent with the registrar's remarks. Secondly, my lady, the demo of the IEBC system architecture, the theory is proven by the registrar. IEBC provided a demo of their election infrastructure for agents to understand. We were not doing it in vacuum, my lords, my ladies. I will leave the comment on the server, my lords, my ladies, for later on. I will now just show compliance. On order three, from the registrar's report, my lords, my ladies, it was fully complied. You can look at the remarks by the registrar, and it says provided. And critically is the penetration test, what is known as the pen test, under the election technology regulations, regulation 10 and 11, but Senior Mugo said was not provided. My lady, I'll take you to page 18 and 19. Supreme Court Order 3, penetration test reports prior. IEBC provided report on internal network and infrastructure vulnerability and assessment, and certificate of penetration were provided to the applicants and the first respondent. Volume 2, page 1 to 51. It's not a theory. A document was granted, and it had 51 pages. My lady, on Order 4, I can confirm we personally filed under seal all partnership agreements with the court, and the registrar notes as much. So, my lady, contrary to the assertion provided in public by counsel, we fully complied. And the only issue we never complied was partnership agreement provided to court under seal. And the issue of server, yesterday at 1:02 p.m., the court and all parties were issued with a forensic image of Form 34C had delivered and by email, my lords, my ladies. That was compliant. And it had a hash key. And it had a certificate of forensic evidence generated by Martin Nyaga. There is a certificate in court, my lords, my ladies, that the hash key was provided. So rather than move to generalization at a granular level, we can prove we fully complied with the orders on ICT. Now, I'll pick issues on the party interrogation into the system. And I want to pick issue 1, it's by George. The same George, I said, is an agent of Mr. Mugo and is proven by the registrar's report R2, the person under 13, for Madva Wangari Karua, George Joroge, and Musa Omondi. That is the George. He asks, wanted to know the user who logged in on 12 August 2022 at 001 hours. I will take you to R9. It's the registrar's report. I have not filed anything in reference to this, my lords, my ladies. And it shows there was no user. It's the registrar's report. I'm not going to give an interpretation. And I will say the comment under, by the registrar, a review of access laws did not show the user or any suspicious activity. The registrar was represented by an IT technical team. So it did not even request us to lobby the registrar, explain to the registrar. The IT team confirmed for itself. My lords, my ladies, they said there was suspicious activity between various dates. I will take you to comment 4 by George Joroge. Agent wanted audit logs for user root during the election period. Logs were retrieved from 8th August to 29th August 2022, the day before the election and the day before we did the exercise. There was no suspicious activity. I would like the court to do a simple thing, my lords, my ladies. Compare the logs Mr. Mugo has provided and what is found in the registrar. You will discover there is an apparent discrepancy on the face of those logs. Nothing put on the slideshow is in the registrar's report because it's not. He may clarify where he got that, but he'll simply refer to the registrar's report. It's not, my lords, my ladies. Now, when you move on with the report, you get other clarification by other users, and I want to pick three that are quite pertinent. They say there was no way of ascertaining the date of the server log, and that was the opening comment. At page 22, comment 8 by Victor, agents wanted to know when Form 34C was uploaded. This was established to be 16th August 2022. How could have it been created on 31st August, but you are able to go back in history to 16th August to determine when Form 34C was uploaded? It's ridiculous on the face of it. My lords, my ladies, I'll take you to George again, page 23. The agent requested to see the whole architecture. The whole, not only RTS, not only KIMS, the entire IBC infrastructure, including everything retained in that server. IBC database admin presented the system architecture and explained the transmission flow. How can you say access was not granted when it was granted the entire architecture, not RTS? My lords, I notice my time is running, and my senior wanted to refer to the forever. I will stop here, but if given time, we can take the court through the entire report and answer every query raised satisfactorily, because it was done. Access was granted, that's why comments were made. If access was denied, there would have been no comment. Thank you, my lords, my ladies.